Welcome, friends and colleagues, to this World Commission on Environmental Law webinar about environmental liabilities and biodiversity. My name is Jacob Phelps, and on behalf of the organizing institutions and speakers, it's a pleasure to have you with us as we explore the ways in which environmental liability legislation might be more broadly applied to help address some of the leading threats to biodiversity around the world. As a conservationist, I'm interested in the ways in which law might help us to address wide-scale harm to biodiversity, whether it's from illegal deforestation, mining, illegal wildlife trade, whatever the cause. I'm interested in what happens when these original systems are injured. Typically, we respond with questions like, okay, well, in the face of harm, how might we make enforcement stronger? Might we increase sanctions? Might we make prison terms longer? Maybe we could become more effective at detecting harm to biodiversity, detecting violations, and making our prosecutions more successful and stronger. Or perhaps a typical response is trying to figure out how we might even reduce one of the drivers of biodiversity loss in the first place, things like perhaps demand reduction. These are all incredibly important responses into which we've invested a huge amount of effort and resources as a community and have made considerable progress. But one of the challenges that we face as environmentalists is that these types of legal responses to harm typically don't address the issue of remedies. That harm system, if someone goes to prison, or if we increase prosecutions or address drivers, that harm system is not necessarily ever remedied. And it's precisely those remedies that we're going to be focusing on in today's webinar. We're going to be looking at how the law might be able to provide a recourse for biodiversity when it's injured so that we can somehow restore, compensate, remedy, make whole, fix. And so some of the questions that our speakers are going to be exploring today are questions about how we conceptualize that harm in that first place and how it might be offered remedies. But then, of course, what would the law allow? What will judges and juries accept in court? And of course, what is just and strategic going forward? As a conservationist, a lot of these legal concepts are new to me, and they may indeed be to you. But one of the things that has become obvious to me when engaging with these issues is precisely how multidisciplinary they are. And that is well reflected in today's speakers. These indeed are questions for lawyers, but they're equally questions for activists, conservationists and ecologists, geographers, economists, as you'll see, even legal psychologists. And so it's really a pleasure to welcome this incredibly diverse group of scholars, of academics, but also practitioners from across 5 continents. From 7 a.m. on the west coast of Canada to 10 p.m. in Singapore, we're going to be hearing a series of lightning talks from some of the leading thinkers on these issues around the world. And I hope you enjoy it. So without further ado, I'd like to welcome our first speaker, someone who perhaps requires really very little introduction, the chair of the IUCN World Commission on Environmental Law, and also a justice on the National High Court of Brazil, Justice Antonio Herman Benjamin. Thank you very much. Over to you, Antonio.
Thank Jacob. As you mentioned, this is the most fundamental issue for the protection of the environment. This is the cliche. But cliches matter in environmental law. The obvious needs to be repeated in environmental law, especially for judges. And in this panel, this webinar, we are going to have the opportunity to explore environmental liability, not just from a pollution perspective, which is the area in which in environmental law, treaties and hornbooks, we see the development, cleaning up efforts in areas contaminated by toxic waste, and so on. But we will be discussing environmental liability, and to me, in a much more complex context than just brown environmental law, which in itself is also tremendously complex. But before I move into the specifics, or some of the specifics that I'm sure my colleagues will explore in depth, it's important that we put this in a broader picture. Environmental liability or liability. And why do I say this? Because as Jacob mentioned, and that's not a scene of environmental law, but of the legal system, because it takes us to the origins of law. The focus has always been on punishment, from the Hammurabi Code all the way to canon law. So here we have to understand that liability, and not criminal or administrative liability, but liability for civil damage, is a major component of the toolbox of environmental law. And it's probably the most complex of all three types of liability in the environmental context. Sending people to jail or paying a monetary penalty in administrative procedure, that can be complex, but it doesn't even approach the boundaries of the complexity of environmental liability, for the reasons that will be explored, I am sure, by my colleagues, especially those that come with a science background. You notice in the slide that Jacob projected that one of the sponsors of this event is INES, the International Network of Environmental Compliance and Enforcement. And you might wonder why. Well, not long ago, environmental law, as other fields of law, contract, torts, commercial law, the perception or the conventional wisdom was that, the role of the legislator is to enact laws, and the implementation of those laws would be left to the individual victims. It's not our business. Later, we found out that that there is a gap there. That the environmental law, because of the types of values that are protected, require that compliance and enforcement be joined as the other side of the coin of rights and obligations. And this is a fundamental challenge to judges, because we are educated under the premise that those two things are entirely separate. So this is the first challenge that I would like to emphasize: the need to see environmental civil liability as a component, an absolutely necessary component of the compliance and enforcement box of environmental law. And just enacting rights and obligations doesn't help the environment, doesn't help people. It might even, if there is no compliance and enforcement, might even be a detriment, because it gives a false impression that people are protected, that the environment is protected, when in fact it's not. Moving to the end of this introductory remarks, it is important that we, in addressing environmental civil liability or civil liability for environmental damage, that we recognize that within this umbrella, there are different dimensions. There is the theoretical legal dimension, which is, we cannot just reproduce the theoretical knowledge that we build up for ages in torts and civil liability, and say, we are going to apply this to environmental law. It doesn't work. It's not feasible. And in fact, environmental law has been at the forefront of the modernization, so to speak, of torts. I would say, if I were to name the area, the legal discipline that has been at the forefront of updating tort law in common law system and civil law systems, I would put environmental law as, if not the main, one of the main legal disciplines that by nature have to do it. So the theoretical challenge is one that we should not forget. It's still important to work on the theoretical foundations of this new building that's still under construction. But here comes another component that often is not pervasive in other areas of law when we deal with torts, which is the role of science. In civil liability for environmental damage, we have to bring the scientific knowledge from economics, from ecology, from geology, from climate, everything together. And this makes the lives of judges very, very complicated. But not impossible, because judges are used to this type of complexity. It's just of a different nature. My final comment is on the need to be mindful of not trying to just transplant models, especially for assessing natural resource damage from more developed countries into less developed countries where those resources are not there. Deep in the Amazon rainforest, in areas that we can arrive only by helicopter. How can we apply? That's the question that we need to always have in front of us. How can we apply a system that is very sophisticated, that can be used in Love Canal and in other places, but might be impossible under the circumstances? And then making sure that the legal system of those countries have a package of remedies, including first and foremost restoration, and then adding in this basket other possibilities from some of them not that complex, other very, very, very complex. So this is the dimension from my own, or the perspective from my own country, because if we make it too complex, we are in fact playing the hands of those that damage the environment, the polluters, those that clear forests, because we are opening up litigation for all those challenge complexities and so on, and suits that should last not more than 2 years will take 20 years, if so, to be resolved. So at the end of the day, we need to have this, the local circumstances into consideration, but making sure that in whatever system, legislative system or theoretical system that we adopt, the result is that damaging the environment doesn't pay off, that it doesn't profit those that damage the environment. So Jacob, I will stop here. As you saw, I have more questions as a student than answers to the very important propositions that you have in this webinar.
Thank you very much, Justice. I'm enthusiastic to hear that you see this as such an important area going forward, and thank you for those very high level but also very pragmatic observations on the challenges ahead for furthering this type of work. I'd like to welcome our second speaker, Dr. Valerie Fogleman, who is a professor of law at Cardiff University, School of Law and Politics, and a consultant at Stevens & Bolton LLP. She is a U.S. attorney as well as a solicitor and has taught and practiced environmental law for over 25 years and has carried out several projects for the European Commission on the Environmental Liability Directive. And so here to speak to us about the opportunities and challenges of operationalizing these sorts of liabilities for harm, and specifically in the context of biodiversity. So Valerie, please, over to you.
Oh, thank you very much, Jacob. Let me just, I am not good at technology. I am very honored, first of all, to be amongst this very august group. So my deep, heartfelt thanks to Jacob and the other organizers for inviting me. I thought at the beginning when I started preparing my presentation, I would just summarize environmental liability, because this is what I do most days, look at research and write on environmental liability. And then I realized what I'm really doing is summarizing two excellent articles that Jacob helped write. So over to Plan B, and I'm going to look at how do you frame the, first of all, how do you frame the legislation for imposing environmental liabilities for harm to biodiversity? And it's difficult. It is extremely difficult, because what you're really doing is you're mixing environmental and conservation legislation with massive tensions between them. So just very briefly, environmental legislation, the phrase protection of human health and the environment is ubiquitous. But what does it really mean? It means protecting human health and protecting the environment as it affects human health. Protection of the environment is a very, very distant second, and not enough attention is paid to it in so-called environmental legislation, especially on, I say, risks from air, soil, water pollution, chemicals, and waste. And it's not about future generations either. It is about us, people that currently live now. So looking at conservation legislation, very, very different. It's not the polluter pays principle that you see in environmental legislation. And there's a lovely quote from Eric Freifogel, who used to be my boss when I was at the University of Illinois. And what Professor Freifogel is saying, nature conservation legislation is about protecting nature from people. And because of that, you've got these obvious tensions. And so you get it enacted with very high aspirations, US Endangered Species Act, like at the forefront of conservation legislation, passed nearly unanimously by the US Congress. But then we had Tennessee Valley Authority versus Hill. And that was a challenge to a dam that was over 80% built. And surprisingly, maybe the US Supreme Court stopped the dam. The dam was built afterwards, unfortunately, but that's an entirely different story. But then Congress revises the legislation and introduces a so-called God Squad to say, now we can look at exceptions from it. We're lowering these aspirations because economics and social factors get in the way. Same thing over in the European Union with the Birds and Habitats Directive. Commission versus Germany goes to the now Court of Justice of the European Union about reducing the size of a protected area to build a road It did succeed, but it was on these very, very high economic grounds, and because it posed a risk to human health. So what does the European Union do? They introduce exceptions to it. So just to look at how these work very, very briefly, in the so-called Superfund Act, US Comprehensive Environmental Response Compensation Liability Act. Now, the key reason for that act, way back from December 1980, is retroactive liability for cleaning up contaminated waste sites across the EU. So obviously retroactive, as well as strict modified joint and several liability. The EPA enforces, has a big Superfund program, no liability on cleanup costs. Nature conservation is then added, natural resource damage, but some of this protection is actually protecting natural resources for people. So it's on its perspective, it's not retroactive. It's enforced by natural resource trustees, which is absolutely fine, but there's no program to restore damaged natural resources. The causation requirements are more stringent than for cleaning up waste sites, and there's a limit of liability. So then look at another act, another legislation, the ELD, the Environmental Liability Directive. The primary purpose in adopting this directive is to assist in halting the loss of biodiversity in the EU. So whereas strict liability on specified operators is imposed for preventing and remediating damage to land, waters, and biodiversity, fault-based liability onto any other operator is imposed only for preventing and remediating damage to biodiversity. Prospective only, same companies, same competent authorities, no limit on liability. So this is an attempt to get nature conservation into an environmental law. Well, first of all, it was highly controversial. It took years and years to pass because of opposition to it. A large reason because industry and insurers said you couldn't quantify damage to natural resources, whereas you can. Some concepts were drawn from the Superfund Act, primary, complementary, compensatory remediation. So you not only clean up a site, you restore the biodiversity. But in doing this, what the European Commission rejected is a very wide definition of biodiversity that's in the Convention on Biological Diversity. And also because of the opposition, the liability provisions were watered down. So when you look at the biodiversity that's protected by the ELD, it's quite narrow. It's limited to species and natural habitats protected by the Birds and Habitats Directive. And I've got a few definitions there, but just to jump to the threshold. The threshold is determined by reference to the conservation status of a natural habitat or species in 3 areas: European territory of the member states to which the treaty applies. So that doesn't include the outer countries and territories like the Canary Islands, the Azores, or the territory of the member state, or the natural range of a habitat or species. Well, the natural range of a species, when you're looking at wolves, for example, is very broad. These are very difficult thresholds. Most member states and competent authorities think that this so-called significance threshold is very high, whereas it's not. And when you look, for example, at Poland, in Poland, what the authority has actually published on its website is to say that if you pretty well wipe out a species from a certain area, that will still not meet the threshold under the directive, unless it's a very rare species, and that's basically the only place where it exists. So what happens is basically ignored in a lot of member states. They continue to enforce the legislation that they've got before, most of which, in fact, nearly all of which, except for a little bit in Germany, means that they're just cleaning up. They're not restoring the habitats. So, as I say, it's very difficult also to determine if this threshold is reached or if it's been exceeded, because the ELD sits on top of member state laws. So compare that with CERCLA. No relationship between NRD, natural resource damage, and nature conservation legislation under CERCLA. So which should you do? I say, I'm just raising these questions. So when a country is looking at introducing legislation for conservation litigation, you've got to look at it very, very closely.
Apologies, Valerie. I'm going to ask you to wrap up when you get it.
Okay, sorry, I will do. Thank you. Sorry, I will skip past this one, and just to say, when you're looking at standing, actually in the global south, they're ahead of us in the global north with introducing this legal personhood. Just a couple of innovations, so-called, under the French Civil Code. There is now liability for ecological prejudice that can be brought by just about anybody, right? But it's got a very broad scope of biodiversity, and some of that legislation doesn't really succeed. And then really finally, just look at the European Commission's proposal. The nature directives, birds and habitats directives don't go far enough. So what the Commission is doing is proposing a restoration law in 2021. Will that be linked to the ELD? Maybe. It probably will not include provisions for preventing or remediating biodiversity. And so basically it's essential that we have this legislation, but there's many challenges to how exactly it should be framed. My apologies for going over my time. That's it. Thank you.
Hardly. Thank you very much, Valerie. And we've given you an impossible task to deal with what increasingly from your input sound like some of the really leading challenges for environmental law, and indeed legislation that's rapidly evolving, including in the EU. So a very difficult topic to address with any level of succinctness. I'd like to introduce our next speaker, who will also be known to many of you. Dr. David R. Boyd is the UN Special Rapporteur on Human Rights and Environment, and author of 10 books, including The Environmental Rights Revolution and The Rights of Nature. So please, David, take it away.
Thanks very much, Jacob. I guess I'm the odd duck on this panel, which fortunately not an endangered species, but I'm not really speaking directly about liability. Everyone attending this webinar knows we're in the midst of a global environmental crisis. And in recent years, there's been quite a bit of progress in recognizing that there are linkages between the climate emergency and human rights, thanks to the good work of the UN Human Rights Council, small island developing states, civil society. I think we're at an earlier stage in terms of recognizing that there is an equally close relationship between biodiversity, healthy ecosystems, and human rights. My predecessor, Professor John Knox, did a report to the Human Rights Council. I did a report on this subject to the General Assembly last year, but I think we're at an earlier stage. And yet the reality is this, that the air we breathe, the water we drink, the food we eat, all completely dependent on biological diversity and healthy ecosystems. Healthy ecosystems provide buffers against diseases, which has been so painfully demonstrated by this COVID-19 pandemic that we're all still embroiled in. You think of pollinators for food. The list is endless. And so human rights really do depend on healthy ecosystems and biodiversity, which raises the question, well, where does environmental law come into this? And environmental law, despite some successes in recent decades, has not really addressed the climate emergency or the biodiversity crisis. Greenhouse gas emissions are up 65% since nations agreed upon the UN Framework Convention on Climate Change. Not a single one of the Aichi biodiversity targets articulated by parties to the Convention on Biological Diversity was met by 2020. And I think it's really important to recognize that the Achilles heel of international environmental law is the lack of enforcement mechanisms, which results in a lack of accountability. And that's where human rights enters the picture. What if we actually synthesized human rights law and environmental law, brought them together? This is what the UN Human Rights Committee suggested in its general comment on the right to life, when they said that international human rights law needs to be informed by international environmental law, and environmental law needs to be informed by human rights law. So in recent years, we've actually seen a surge in rights-based climate litigation. People will be familiar with the incredible decision of the Supreme Court of the Netherlands in the Urgenda case. More recently, the Constitutional Court of Germany in the Neubauer case. Courts finding that governments are breaching their human rights obligations by failing to take ambitious action to address the climate crisis. And many other decisions from other countries, France, Belgium, Pakistan, the list goes on. There are really exciting cases currently before the UN Human Rights Committee, the Committee on the Rights of the Child, and 2 cases accepted by the European Court of Human Rights and indeed fast-tracked by that court. So rights-based climate litigation is having an impact on the climate emergency. And I think that's really exciting. And the next question is, are we going to see a similar surge in rights-based biodiversity litigation to hold governments accountable to the commitments they have made as parties to the Convention on Biological Diversity to stop the tide of extinctions, to stop the decline of biodiversity? And I think my answer to this question is yes. In fact, human rights are already being used to protect biological diversity. Some extraordinary cases from around the world. Decisions of the Constitutional Court of Costa Rica to protect the habitat of endangered species. Decisions by the Supreme Court of Mexico to protect mangrove ecosystems from development. A case in Uganda that prevented a monoculture plantation from going into a protected forest. Cases from India and Peru that stopped shrimp aquaculture from damaging mangrove ecosystems. And so I think that the human right to a healthy environment is really being interpreted in 2 ways. And this kind of touches on what Valerie was talking about. The right to a healthy environment is being interpreted by courts as healthy for humans. So it addresses air pollution, water pollution, and toxic chemicals. But the right to a healthy environment is also being interpreted as requiring healthy nature, healthy ecosystems, and healthy biodiversity. And one of the most exciting decisions in recent times was the decision of the Supreme Court of Colombia in the Future Generations case, a case brought by 25 children and youth, arguing that their constitutional right to a healthy environment is being violated by deforestation in the Colombian portion of the Amazon rainforest. And the Supreme Court of Colombia ruled that those children and youth were indeed correct in their assertion, and that their right to a healthy environment was being violated by deforestation. And obviously, deforestation is closely linked to both climate change and biodiversity loss. So I think that this area of rights-based biodiversity litigation is tremendously promising as a way to prevent the further decline of biological diversity. And I think that's one of the key points, is that liability approaches are terrific in terms of potential restoration and rehabilitation. I think it's unclear to what extent they can be used to create deterrence to prevent future acts that will impair biological diversity. But when we look at the gravity of the global biodiversity crisis, we have to use every tool in our toolbox, and we have to prioritize the use of tools that have a track record of making a difference. So I encourage everyone on this call to study this, to implement these tools, and to take action, because that's what the young people of the world, the scientists of the world are telling us, that we need urgent action to address these interlocked crises. Thank you very much.
Thank you very much, David, for that, again, for that broad view, but also for a call to action, which is indeed one of the things that we're going to be exploring in kind of this next set of talks, which start to explore the potential for using these sorts of laws, which are, as we're going to hear, on the books in many countries. But how do we move beyond those protections that are guaranteed to us and actually start to think about operationalizing those? And so I'd like to welcome our next speaker, who's a stalwart of the environmental law community with decades of experience in the United States. John Pendergrass, Vice President for Programs and Publications at the Environmental Law Institute, who's going to offer us an overview of environmental liability legal authorities around the globe. Please, Jay, go ahead.
Thank you, Jacob. And yes, so I am going to give the high-level overview of what exists out there in terms of laws relating to the topic. Next slide, please. And this, thank you to Valerie for giving a more detailed discussion of the EU liability directive, since a lot of this relates to comparisons between US, the EU directive, and what other countries have. So we're talking about environmental liability for harm to natural resources, biodiversity. I've listed the wide range of potential resources. Examples, we've heard about oil spills and deforestation, which are oil spills is certainly the most common application of this, as Justice Benjamin was discussing, but it has been brought up in terms of illegal wildlife trafficking recently. Next slide. So one of the first things is to make a distinction between harm to private property and private resources and harm to public resources. We are concerned here with the harm to resources that are either owned by the public or held in trust for the public. As Professor Benjamin talked about, the tort system can deal with the private losses. The scope is potentially all of the resources that are held in trust, air, water, land, soil, biological diversity, et cetera. But we'll see that in many cases, the scope of the legislation is more restricted. The liability standards, whether it's strict in several potentially joint liability or based on some form of fault, such as negligence. And then, as Valerie already mentioned, the question of who can bring the lawsuits. And I completely agree that the Global South, in many ways, is ahead of the US and Europe on this when they allow affected communities and individuals to bring the cases. So next slide. And another feature, is application of the idea of polluter pays, but the polluter paying for what? The standard has been to, in environmental laws, stop the harm, possibly then to remove the oil spill or a contaminant, clean up, but the restoration is the key element that we are concerned with environmental liability for harm to biodiversity. It's restoring the injured resources, and the concept that the next speaker will go into in more detail about making the public whole, which is compensating for the losses between the time that the harm occurs and when the resources are fully restored. Then there's also the question of where does if you're recovering money, where does it go? Does it go actually into restoration, or does it go to the government's treasury and just become part of the full general fund? Next slide. So as Jacob mentioned, this is environmental liability is present in a number of countries. It tends to be, particularly in the Global South, as part of a general framework law that covers all of environmental law. And that allows for liability for harm to natural resources of biodiversity. And I have listed some of the just examples of countries from the different legal systems around the world. It's present in common law countries. It's present in countries that use the civil law systems, and those that are somewhat more mixed, such as Indonesia. Next slide. So there are a couple of elements that I wanted to highlight. The US and the European Union, as Valerie went into to some degree, it's based on the particular EU directive, US national laws that create liability for named types of harm and named types of resources. The one caveat to that is that both the US and the EU allow cases of the US states or member states in the EU to do more than. So in the US, the states, by virtue of their authority for public trust, can go much beyond what the federal government does. But as I said, there are overarching statutes in many of the countries in the global South that establish broader coverage. And in standing, the global South, because of the framework laws, have tended to allow both government and civil society to bring suits, whereas in the US, it's more restrictive to just the government. Next slide. The other way around, though, the US and EU, at least in the legislation, have been broader in their coverage of what the recovery can be for under the CERCLA statute. The cost of restoration is a measure. What is referred to as interim loss is something that is less present in other countries. And Antonio Benjamin spoke to one possible reason for this, and that it's certainly more complicated. There are countries that have it, but the practicalities have intervened. Next slide. These laws have, though, been applied in relatively few cases. We have seen them applied for destruction of peat forest in Indonesia, one of the leading cases in the world. But there are then problems of implementation of the decisions, so that it can be tied up for years beyond the actual decision to actually getting something done on the ground. One of the larger awards was for oil spill in Nigeria, but it was limited to really the damage caused to the individuals who were harmed. Next slide. And it just comes down to that there, so far, the laws that exist where there is potential to bring cases have not been, there haven't been very many cases brought and successfully resolved. One of the key issues in implementation is that the amounts awarded tend to be very low relative to the injuries. And then there's the problem of where does the money go? And too frequently, it doesn't go into actual restoration, or it's not guaranteed to go for restoration, but rather go into a general fund. Again, a long time before or if money actually is dealing with the resources, the biodiversity that was actually harmed. Next slide. So there are a whole lot of problems that countries face, whether it's civil war, corruption, the issues of political will, unfortunately, one of the things that we've seen is that the tendency is not to sue the large or powerful companies or the people that are really behind harm to biodiversity, but rather the small farmers or other people or the individual wildlife traffickers who don't really have control over the major issues. There are many other issues in terms of the science and data. Justice Benjamin mentioned that it's can be complicated to bring some of the cases, to bring everything to bear. But it's one of the things we need to work on developing, and education could be part of that. Next slide.
Jay, I'm going to ask you to wrap up if you please.
Yep. So the takeaway is that it's the laws exist, but they have not been used very much, and we're trying to put forward the possibility that this is an underused policy tool that could have a lot greater impact than it does. Thank you.
Thank you very much, Jay. It's encouraging to hear that ostensibly the laws to hold people responsible for the harm they cause and responsible then for providing remedies to that harm are existent in many countries, but perhaps as is often the challenge across so many areas of life, operationalizing those is a significant challenge. Thank you very much. I'd like to introduce our next speaker, who has, I think, a really unique set of experience. Dr. Carol Jones is a visiting scholar in environmental economics at the Environmental Law Institute. And this follows a 30-year career in both academia and government. And notably, and perhaps most relevant to today's talk, she was the lead economist at the US National Oceanographic and Atmospheric Administration in developing innovative restoration-based approaches to remedies under the Oil Pollution Act that we've been hearing about. And this passed following the devastating 1989 Exxon Valdez oil spill. While at NOAA, she oversaw the valuation of natural resource damage claims for 36 cases in which NOAA was a trustee for the coastal and marine resources. And this recovered over $190 million in addition to the $1 billion Exxon Valdez settlement. So she has a great deal of experience thinking about how we conceptualize and indeed sometimes put a monetary price tag on harm and what that means when it intersects with law. So Carol, please go ahead.
Thank you very much, Jacob, and greetings to all from Washington, D.C. As I will be speaking today about valuing damage claims from the Exxon Valdez oil spill of 1989 to an illegal wildlife case filed in Indonesia 2 months ago. The Exxon Valdez oil spill is widely considered to be one of the most devastating human-caused environmental disasters, and those of us of a certain age most likely have vivid memories of the spill, which held the record as the largest tanker spill in U.S. waters until Deepwater Horizon in 2010. Now, this slide that you're looking at is a picture of the tanker, the Exxon Valdez, and the beginning of the spill in the pristine environment of Prince William Sound in Alaska. I'm highlighting this case because it was a signal event in environmental liability litigation in the US. It was the first really big environmental liability case, and it really triggered the US government to develop a natural resource damage assessment program to carry out its liability responsibilities under the various statutes, not just for this spill, but for other harms. And as a result, that was when I joined the federal government to work on these issues. Second, as Jacob mentioned, it led to the passage of the Oil Pollution Act in 1990, which strengthened regulations to prevent spills and also set out the most complete set of liability provisions of any US statute. And finally, the controversy associated with the approach used to value the Exxon Valdez claim led to reframing claims for damages under the new Oil Pollution Act as a restoration plan, as I will explain in my talk. And addressing Justice Benjamin's challenge, I believe this approach is transferable to developing countries, unlike the approach used in Exxon. So the oil spilled from the tanker spread from Prince William Sound, which is marked in red in the upper right of the map, and eventually covered 28,000 square kilometers and affecting many pristine ecosystems across various protected areas. Next slide, please. Many species of birds, fish, and mammals, which are endangered or threatened in other parts of the country, experienced large spills, and habitats were impaired, resulting in long-term population losses. Studies over the years have highlighted the long recovery periods. Of the 25 priority species and habitats that were followed over time, at 15 years after the spill, none had fully recovered, and 11 were not recovering at all. At 25 years following the spill, 14 had fully recovered, 4 were not recovering at all, and the rest were in the recovery process. Next slide. Back one. Oops. Oh, sorry. Yeah, the Exxon Valdez claim was brought under the Clean Water Act, the statute prior to the Oil Pollution Act. And on this slide, I outline the concepts underlying the claim for natural resource damages, which are carried over to the Oil Pollution Act. First, the goal is to make the public whole for natural resources. Then there are 3 elements of a claim. The first is the cost of restoring injured resources and services to their baseline, or replacing them if restoration is not feasible. The second is compensation for interim losses from the time of the injury until resources recover to baseline. And the Exxon Valdez studies highlight how long the period to recover can be and how important this element is. The third element of the claim is reasonable cost of assessment. And the final key point is that all of the US laws have a statutory restriction that recoveries must be spent on restoring or replacing resources. Next slide. As I said, this was the first big US environmental liability case. The approach to valuing the claim for damages focused on valuing interim losses using a survey-based method, contingent valuation, to elicit willingness to pay to prevent the harm, which is a proxy for what we really want, which is the compensation required to make the public whole. Restoration planning was left to another day. The natural resource damages settlement was $900 million plus a $100 million contingency, which got it up to the billion that Jacob referred to. 2/3 or more of it was for restoration of resources. But post-settlement, there were years of controversy about how to spend the recoveries. There were also controversies about the valuation method, which had yielded a high damage estimate. So when we were writing the regulations to implement the Oil Pollution Act, industry lobbied very strenuously to restrict use of valuation methods. Next slide. But beyond the controversies, it was also the case that valuing willingness to pay using a survey instrument like contingent valuation, where we're asking, how much are you willing to pay to prevent future harm? This does not inform decision-making about how to spend recoveries on restoration. So for the Oil Pollution Act, we developed an alternative approach. The statute states the compensation for interim losses is to be provided in the form of resources. So we need to figure out how much additional resources does the public require to be made whole for the loss. And so the damage claim then becomes the cost of a restoration plan, with primary restoration projects designed to expedite the return of resources to baseline, and compensatory restoration projects designed to compensate for the interim losses. Next slide. So what would compensatory restoration projects look like? The priority is given to in-kind projects as with primary restoration. So for example, if the spill injured or destroyed mangrove habitats, then projects could rehabilitate comparable habitat nearby or acquire and protect comparable habitat that is threatened by development. For injured resources, projects could rehabilitate injured animals and adopt practices that will increase the likelihood of population success. For Native American cultural losses, projects could fund cultural institutions. Next slide. One application in the US was for the Blackbird mine case in Idaho, where the tailings from the mine killed streams where threatened species of salmon had lived. And in the photo, the shocking blue color of the drainage is due to the copper in the tailings. The damage claim was calculated based on the cost of undertaking actions to restore the population sufficiently to replace both the baseline level of 200 spawning Chinook salmon, as well as the interim loss in spawning years. Next slide. Jay highlighted that internationally, environmental law cases have been brought for a wide range of claims. And the photo that you can maybe vaguely see in the background is of artisanal mining, which is notoriously harmful for the environment as well as for human health. Now I want to highlight a recent Indonesian case for a relatively new application of liability, illegal wildlife use. Next slide. In Sumatra, a local NGO, Wali North Sumatra, recently filed a case against an illegal zoo, which has been displaying 43 animals from protected species. The photo is of the Sumatran orangutan at the site, who has now been rescued. Focusing on remedies for the critically endangered Sumatran orangutan population, the suit is asking for the cost of long-term care of the rescued individual, which cannot be returned to the wild, and costs of additional patrols and scientific monitoring in North Sumatra to help the population recover. To address the impacts to humans, the claim requests financial compensation to develop educational exhibits about the illegal wildlife trade and its impacts, as well as a public apology for the injuries caused to society. So I want to conclude with some lessons learned from the US experience over the decades since Exxon Valdez. And in the interest of time, I will just focus on the first two. One, including compensation for interim losses pending resource recovery is really essential for full compensation given long recovery times. And two, focusing on restoration planning in the US has been very effective in skirting valuation controversies and moving cases toward resolution and speeding implementation of restoration. And I might add, I think it is an approach that is implementable in developing countries, as we see in the North Sumatran case. Thank you.
Thank you very much, Carol. I think that there's often a reluctance to, or a confusion over how do we come up with values in these sorts of suits. And you have a broad experience across a range of cases that illustrate that this can be done in ways that are meaningful, signals to society about what has actually happened, but can also secure remedies, including some remedies with a huge price tag that sends important has corrective remedial functions for injured biodiversity. So thank you very much for those insights. And it's encouraging to see that across that breadth of experience from a pollution case in the late 80s through to this more recent Indonesian example focused on wildlife trade, that there is a range of precedent cases to which we can refer. Continuing on in Indonesia, I'd like to introduce Rika Fadrini, who's a research associate with the Indonesian Center for Environmental Law, and Dr. Taufika Purna Nugraha, who's a researcher at the Indonesian Institute of Sciences, who are going to be talking about efforts in Indonesia, creating a guideline to help practitioners think about how these sorts of cases might be developed in practice, dealing with all of the challenges and complexities that colleagues have been addressing in their previous talks. So please go ahead, Rika and Taufik.
Thank you, Jacob, for the opportunity to that you have give us to present our work on pioneering civil lawsuit for harm to threatened species. We have developed a guideline on this topic, and it takes the example from Indonesia, but I believe the general concept and then the problem that we encounter might also be relevant with other countries' problem. As you know, that Indonesia is hosted a lot of critically endangered species such as Sumatran tiger, Borneo orangutan, and also the hornbill. And with that privilege come a great responsibility to manage this species. And this species has been threatened by two sources of harm. The first one is harm to their habitat by, for example, by the forest fire or illegal logging, and also by harm directly to the individual species, like in the case of illegal wildlife trade. For the case of harm to habitat, as Carol and Jay also mentioned, that worldwide there has been a lot of example on how to bring a liability damage claim on this type of cases. In Indonesia also it is common to bring cases on forest fire, but in the case where individual species are directly harmed, we call it species-based harm in the guideline, it is rarely used, the civil liability instrument in this case. Despite the fact that illegal wildlife trade itself is the highest number of environmental criminal cases dealt by the Ministry of Environment and Forestry, but it only been dealt with the criminal law that you also have been mentioned that it focused on jailing people or punishing people with fine, the fine that does not really correlate with the harm that is occur. So the question is whether in this type of case, is there any harm that occur and need to be remedied? And we found during our study to develop the guideline, actually there are several harm when, for example, one endangered species such as orangutan is harmed. First, it harm to the individual species itself that they could require a long-term care, rehabilitation, and also the introduction. At a broader level, it also reduced the survivability of the species itself, so it's also harm the population. And at a much more broader level, it's also harm the ecosystem services related with the species. And also it's undermined public trust in the government ability to protect the endangered species. Sadly, all of this harm, the cost has never been a burden of the perpetrator. The cost for the rehabilitation, the cost for introduction are usually borne by the environmental NGO or by the taxpayer through the government. So clearly the criminal law has not responded to this harm yet. It responds to the crime, but not yet to the harm that occurred, especially in the context of Indonesia conservation law. So we see that there is an opportunity that usually overlooked, which is to use the civil law instrument that could provide the order to remedy the harm that occur. So that is the background why we developed this guideline. There will be 6 topics you will find in the guideline that we discuss step by step. It is discussed in Indonesia context and problem, but it might be relevant to other country problem as well. The first one is we talk about the legal basis, the liability rule. How can we bring a lawsuit? And as Professor Valerie also mentioned earlier, there in Indonesia environmental law, there is a problem on threshold, how to prove that a threshold has been exceeded so that it could be said an environmental damage has occurred. In the cases like forest fire, it can be easily been done, but in the case where only a finite amount of animal is harmed, for example, like only 20 birds are harmed, can we say that a certain threshold has been exceeded? That's also the problem that we talk here. And also the next step in the guideline, we talk about the harm. What kind of harm occur when damage to biodiversity happen? There are several harm that we scrutinize: the environmental harm, the social and cultural harm, and also the economic harm relevant to the case. And once we have identified the harm, we identify what type of remedies correspondent to each type of harm. we talk with scientists and conservationists in developing this type of remedies, and they have a really creative and exciting idea of what can be done. So exciting that it is hard for me to bring them to the fact that the law always has its limitation on what could be accommodated as the remedies. So this could be a problem that need to be overcome, the limitation of law to accommodate the possible remedies. And once we found what kind of remedy we want, the next step in the guideline is we talk about how to develop the damage claims, how to develop the case into a lawsuit, like what kind of scientific evidence you need, where you can search the database that you need. And the next step is to discuss on the procedural and for the procedural law that is might be vary from countries to countries. And also the interesting thing when using civil liability is it's open a broader opportunity to a broader parties to participate. As you know, if we only use criminal law, the party involved will only be prosecutor, the state, and the perpetrator. But in civil liability, you open the door for environmental NGO to sue, for the local community to sue. So a lot of more public participation could be encouraged. And the last part is how to ensure the execution of court order. This has been a very big problem in Indonesia environmental litigation that Jay also mentioned, like there has been high amount of money being granted by the court, but there is no real life restoration in the field. So how to make sure that the court order really being implemented. And this guideline emphasizes the way to select or approach the remedy by using the remedial action or restorative justice. So instead of asking how much money the defendant should pay, we first ask what kind of remedial action, what kind of restorative action that we need. And then after that, then we move in talking how much is the cost to do the remedial action. So remedial action that is being discussed in the guide is not only just a cash value, but a remedies action. Like when one orangutan is harmed and it needs long-term care, then we ask for the financial payment for the long-term care. At the second part of my presentation, my colleague from LIPI, Taufik, will explain about how to implement this concept in an illustrative case of orangutan illegal wildlife trade. Pak Taufik, the floor is yours.
Thank you, Rika. So thank you, Rika, for already giving us the overview of the guideline. So to put this in practice, we put an illustrative case of orangutans, live female orangutans, 3 years old, poached from the wild. The illegal trader has long history of commercial trade and trade of threatened species. So he or she own a big business out of this. The animal confiscated and transferred to the rescue center run by an NGO that will eventually release to the wild. However, cannot be returned to its original wild populations. Next slide. So harm has been done. What can we do to avoid further harm to this individual? This orangutan is just a baby. She won't be able to survive on her own. So we have to rescue and transport this animal to suitable facilities, in this case, rescue centers. Element of remedies for this harm is to ask financial compensation for the cost of sending out a rescue team, including porters, veterinarian, and expense for 1 to 2 days. The costs are based on the estimated cost of an NGO undertaking these activities in Kalimantan, approximately $1,000 US. Next slide. But also, how to fix this, the loss of one individual orangutans? The remedies is by restorations and or replacement of ecosystem goods and services to the baseline level as if the harm had not occurred. One remedies that can be done is by returning the orangutan to the wild populations, but it took years of rehabilitation and forest school for this individual to be suitable for their introduction. So there are a cost of long-term captive care of life harm individual. The financial compensation to the third party responsible for the cost of animal care for a period of approximately 6 years We count 6 years because this is like we estimate that it will be released by the age of 9 years after we discuss with some of the NGO. The cost is approximately $250 US per month. For 6 years is $18,000 US. Next slide. After the orangutan are found to be suitable for release, there will be another cost of introduction live individual to the wild or semi-wild populations. This will include transportations and operational costs of 1 month of release into field enclosure and hard release into the wild. The estimated cost is $10,000 US. But for introduction of orangutan, there's also a standard of post-release monitoring, which is taking time for 2 years to make sure the survival of this orangutan, which involving tracking using radio collar to check on the animal progress and survival, and it will cost around to $24,000 US. Next. Despite the introduction effort of one individual has gone from the habitat. So how can we make this whole again? What action can be done to increase the populations to the baseline level as if the harm had not occurred? One example is by reforestation of its origin habitat. Financial compensation for the cost of reforestation at the degraded forest in primary orangutan habitat in West Kalimantan. In this case, action has been already underway at this site by an NGO to conduct reforestations with native flora to increase the food and shelter to facilitate orangutan population recovery. This will involve planting 30 native tree species per hectare of degraded forest over 600 hectares. The 600 hectare number are based on the estimate home range of the female orangutan Kalimantan. As we know, the individual is still infant, so she will still clinging to its mother. So we calculate the home range based on the mother home range. The estimation of this planting is $120,000 US. But since the defendant has already paid for their introductions, we could propose that the defendant contribute 10% to the cost of undertaking of these actions, which around $12,000 US. Next slide. And how about the losses in human direct and passive use of ecosystem goods and services from the time of injury until recovery? So we could propose the defendant to issue public apology, explaining the nature of the case. Also have to have compensable financial cost to developing the content and design of advertisement in consultation with relevant orangutan expert, and placing a full-page advertisement in 4 national circulated newspaper every 3 months, for 1 year at an estimated cost of $1,920 US. Next slide. Developing an illegal wildlife trade case is also expensive. That's why we also seek remedies for plaintiff extraordinary costs for conducting scientific assessment needed for the case. In this case, which include like the DNA test to confirm the species identity and subpopulations, because we have to know where this orangutan came from in order to build this case. So it's for the genetic case, it's around $100 US, and we also need to hire 2 academic experts to prepare the scientific assessment and damage claim. The cost of the expert for 40-hour working hour is estimated $4,800 US at Indonesian rates. And the last is the cost for monitoring implementation of the court order. Plaintiff demands injunction from the court ordering that the defendant and BKS also as co-defendant provide progress report twice a year until all payments are made and remedial action are completed. In total, the estimated financial compensation are in excess of $70,000 US. Next slide. The restorative action and calculation of the costs in this case is just an illustration. In reality, the type of restorative action taken and the cost of can be very case by case. So the guideline that we present here will give the reference and a general overview of type of harm and its appropriate remedies. The guideline can be downloaded at https://conservationlitigations.org/resources. And thank you very much for your attention, and back to you, Jacob. Thank you.
Thank you very much, Rika and Taufik. as someone who was involved in developing that guide, I think it's really the details of thinking about how to operationalize these types of liability suits that's where it gets challenging, right? The laws are there, we understand the principles, there's a general kind of social acceptance that these are perhaps the right things to do, but the challenges is always in those details, both of the science, as you were discussing, Tawfiq, as well as in the law, Rika, and bringing those together is a challenge. And of course, it's not just what the scientists think, it's not just what the law says we can do, it's what the practitioners think is viable, including the judges and juries. And so I'd like to introduce Dr. Rebecca Nichols to talk a little bit about perspectives of those practitioners about these types of suits. Dr. Nichols is in the psychology program at NTU University Scholars Program at Nanyang Technological University in Singapore. She's an experimental psychologist, so a very different view than what we've had so far today. She's got very broad interests in social cognitive psychology and the psychology of law, and strongly believes in the application of psychological science and its power to promote outcomes for the betterment of society. So Becky, please let me turn it over to you. Thank you.
Thanks so much, Jacob. Actually, I'm just having a little trouble sharing screen. I may not have permission to share. Emily, if it's easier to share my slides from your end, that's fine too. Whichever is easiest is okay.
I see you're now co-host.
Yes,
Please
thank you. Okay. Great, good. Good morning, good afternoon, and good evening to everyone in attendance today. I just first want to extend my warmest thanks to WCEL for having me, of course, for Jacob for organizing, and to all of the esteemed presenters for giving us really valuable presentations today. Today, I will discuss with you briefly some emergent evidence about how judges reason with case evidence and argument in a mock trial involving environmental harm. This is work that I have been working on with Jacob and with Rika actually from some time now. So we'll preview some of the findings for you here today. This work actually came about because presumably, like many of you here, we've been interested in how judges would make decisions in the sorts of litigation that you've heard about today. Some of the research team engaged in early informal conversation with the judges about how they might decide in such cases, but it proved difficult to learn much without a tangible case or case facts upon which the judges could rely. But this problem provided a happy opportunity for an interdisciplinary approach. As you've just heard, my background is not as a legal scholar or as a conservation biologist, but rather as an applied experimental psychologist with interest in psychology and law, and also experience in litigation consulting. So with our powers combined, we decided a mock trial might help to uncover a little bit more about how judges would reason in a hypothetical case of interest. Let's pull this up here. So we decided to use a mock trial approach because it is a simulation approach that is traditionally used in the social sciences to often investigate juror, but increasingly judicial decision-making in the context of an abridged, often hypothetical case. In our case, we recruited 32 Indonesian judges to engage with a short vignette about a civil lawsuit resulting from illegal wildlife trade. In this hypothetical case, a defendant who had been criminally convicted of illegally trading one live Sumatran tiger cub and one tiger skin now faced a civil lawsuit brought by several plaintiffs, including the Ministry of Environment and Forests, a local NGO, a local tourism company, and an indigenous organization. In the case, the plaintiffs asked the court to order the defendant to provide a range of different remedies for the harm caused by the illegal trade of the two tigers. Our method looked like this. The study procedures spanned two main parts. Part one was a self-directed online component in which each judge read a neutral statement describing the case and read plaintiff and defense arguments. The materials included short video snippets as well of expert testimony, including academic experts, an indigenous community member, and a park ranger. After reviewing the case information, respondents made an assessment for each of the 11 damage claims that they would be potentially accepting, or rather they would be accepted in Indonesian courts using a 4-point scale ranging from very unlikely to be accepted to very likely to be accepted. After the online session, semi-structured interviews were conducted either in person or by video call to further probe the reasoning behind the judges' decisions, which was really the meat of the information that we were interested in from our judges. To preview our findings here, these are all 11 claims. Some of them will look familiar to you based on our presentations, particularly from Carol, but also Rika and Taufik. And for each of them, we have the percentages of judges who deemed the remedy likely as opposed to unlikely to be accepted. Those are the percentages here on the right-hand side. You can see the claims involve both monetary remuneration, any of the claims involving costs or compensation here, but also non-monetary forms of redress. Those include, for example, R8, public apology, and R9, public service. It's worth noting here that all claims were more often deemed likely to be accepted than unlikely, with the exception of R6, costs to increase monitoring, and R7, costs for conservation education. Conversely, the top two claims deemed most often likely to be accepted include R1, costs of animal rehabilitation, as well as R8, public apology. So naturally, we were most curious about the judges' reasons behind their decisions, and this is where the follow-up interviews play quite an important part. Through thematic analysis of the interview data, we identified 6 key themes that reflect patterns in the judges' stated reasoning. They include, first, conceptualization of harm, causation, and their relationships to the proposed remedies were especially important, which is perhaps not at all a surprise to this audience. However, while this was implicated for all of the remedies, these were particularly relevant in the context of harm to the more intangible values for wildlife and help us to understand the relatively lower acceptance rates for remedies involving, for example, education and cultural activities. Second, the qualities of the remedies themselves certainly mattered. For example, some of the remedies were reported unlikely to be accepted because they were considered too onerous to put into place, or because they required actions that lie beyond the court's control, like public service or actions to increase the tiger population. However, public service, for example, was also deemed likely to be accepted by some of our judges because it seemed to be a suitable alternative when the defendant would be unable to pay. Yet other remedies were considered unlikely because they were deemed comparatively less significant, as in the case of lawsuit preparation costs, another type of remedy you just heard about, which was sometimes deemed less pressing than, for example, costs of animal rehabilitation. Third, fairness was an issue. Some of the remedies were deemed not to be proportional to the harm that was caused, which may have also been the result of others' actions. This includes, for example, costs to increase monitoring. Further, as alluded to earlier, the defendant's ability to pay was taken into account here, and sometimes a remedy was considered less likely to be accepted due to its overlap with government responsibilities, including costs to increase monitoring and costs of transport and destruction of biological materials. Fourth of 6 here, judges commented on the plaintiffs' and defendants' ability to prove their arguments, both in terms of legal argumentation, but also quality of scientific evidence, including expert testimony. Again, no surprise to anybody in this audience. Fifth, the judges also remarked upon the legal bases and precedents that guided their decisions, including prevailing legal principles, previous judgments, and even just standard practice. Judges remarked that several remedies, including public apology, are currently not reflected in written law, but have been implemented in other cases, and because of that would be likely to be accepted. And finally, the judges in our sample also described their judgments in the context of wider social justice. Remedies such as conservation education and even public apology were deemed likely to be supported when they were thought to reform the defendant, educate society about conservation and its impacts, and or promote deterrence of future illegal wildlife trade. So in summary, the judges in our sample seemed receptive to this type of litigation, even in the absence of established case law. Potential plaintiffs should be aware that these types of remedies may be available to them and that the civil courts can promote conservation efforts, a running theme that we've heard about today. However, not all remedies are treated equally, and not only must each case be able to clearly conceptualize harm, but remedies must be tailored to the harm that occurred. Test cases are absolutely needed, but in the meantime, this mock trial method has given us some early insight into our judges' thinking about a hypothetical illegal wildlife trade case, and the findings can be used to guide practitioners to inform their own case strategies. I will end there. Thank you so much.
Thank you very much, Becky. It's interesting to hear more about this in the context of not having very many of these cases, trying to think a little bit about what judges might actually decide when faced with these sorts of scenarios where we're asking them to help us seek to hold those who are causing harm liable for those injuries. And of course, we can rely on hypothetical cases, but there's also a small number of important, globally significant cases on which we can also refer to look at how judges around the world are looking at these types of claims. And to that end, I would like to invite our next speaker, Ophir Drori, who's the director of the Eagle Network, which is focused on investigation and enforcement of against wildlife crimes across Central Africa. Ophir is a conservationist with a number of international awards for his activism. And so I'd like to pass it over to him to explore a little bit of the understanding of what it actually looks like to bring forward these types of cases in practice and what the realities, what the opportunities and challenges might be. So please go ahead, Ophir.
Thank you. I'll try to put some focus both on the experience we have with the actual cases and also some of the obstacles, especially corruption, as it was raised before. I think it's a real factor on application of our ideas. So the Eagle Network is operating in 10 different countries. We integrate the fight against corruption into conservation. We are kind of bodyguards of the entire process, from investigations to arrest operations to actual prosecutions. And we have more than 2,500 major traffickers that we managed to get behind bars. That means arrested, prosecuted, convicted, and imprisoned. I'll explain a bit about the context, and they'll get to the legal part of things and so on. Typically, when we get to a new country, we have a lot of talk and noise about wildlife law enforcement, and a lot of talk about wildlife prosecutions, mainly because of seminars and workshops and trainings. For us, we go straight to the data, we go straight to the facts, and we try to find how many successful wildlife prosecution these countries actually have. And in most of the cases, most of the countries, the answer is just zero, one big zero for forever, for the entire history of the country. That's a strike contrast between the talks about wildlife prosecutions and wildlife law enforcement and actual results. When we try to kind of like understand what are the obstacles that causes that, how do you get to zero when you have a law for a decade, 2 decades, even 3? In our analysis, we found that the first obstacle for wildlife law enforcement and wildlife prosecutions is corruption. The second one is corruption, and the third one is corruption. So by far, corruption has been a determining factor in the application of the wildlife law. So we came with an innovative approach and trying to get a new role for an NGO, a law enforcement NGO. That's a new animal, a new thing. And as a wildlife law enforcement NGO, in trying to use anti-corruption techniques into conservation, and try to follow up with the government all different stages, from investigation to arrest operations to the legal follow-up, and be sort of bodyguards of this entire procedure. And in practice, what it means is that in each one of the countries we have different departments. One department is the investigation department, so we actually have undercover investigators infiltrating the illegal trade, targeting, building trust with high-level targets, so that we can prepare a sting operation so that they can be arrested in the act. All of our cases are in the act cases, in fact. The second department is the operations department, where we work with wildlife officers and police officers in conducting this, in planning and executing these sting operations. I talked about corruption before. Now, with more than 2,500 traffickers arrested, we have the statistics of corruption, and they are staggering. In 85% of all of our arrest operations with governments, we are intercepting corruption attempts, bribing attempts, traffic of influence, etc. And we are not a watchdog group, so we don't look at corruption and then denounce it. We are a law enforcement NGO, so we fight corruption heads-on in the field in real time. But it is staggering to think that a law enforcement system exists with 85% where no law and no order will be produced unless you fight it in the field. The next department is the legal department, where we basically have legal advisors, lawyers. Their work starts already from trying to look at the legality of our own investigations, trying to look at the different aspects of the arrest operation, trying to maximize from that level already the prosecution chances we have to make it the best that we can. Even the interrogation lists are written in advance by our own experts in order to, again, work on how the case will be won before, in the investigation level, in the arrest operation level, in the interrogation level. Besides this, of course, one of the major aspects of the legal unit, of our legal unit, is to follow up the entire case from start to finish and intercept corruption. And if I talked about 85% corruption rate in the enforcement side, then our statistics from more than 2,500 major traffickers convicted and imprisoned, about 80% of our cases, we can tell you who was trying to bribe who was trying to influence the case to release a trafficker. Again, a very staggering and sobering kind of data that explains, that shows that in 80% of the times, the justice system will not produce justice unless you fight it, intercept it, and fight it heads on. Actually, the fight against corruption still continues or stretches from the legal side of, from this legal procedure to the penitentiary system, as we do jail visits of our convicts, of the convicts of the operations every week. And indeed, many of the times they disappear. If they do have enough influence and money, or both, we will see that they will get, we will get themselves released, and we have to get them back in following legal procedures. We also use private prosecutions, private prosecutors that we manage, the prosecutors, private prosecutors on behalf of the state. So we manage those prosecutors, but they are far more accountable and specialized. We can hire and fire, and that brings us far more results. Again, they prosecute on behalf of the state, but we are the one managing it and bringing it about to get a far better level of prosecution. We also developed the claiming of damages. Right now, in all of our cases, we have awarded damages in all of them. Damages can be claimed for various of reasons from our side, from the state side. And for example, it can be a loss of tourism revenue because of the killing of a few elephants. So we calculate exactly what is the role and how many years an elephant lives, and what is the damage and the portion of that damage to the entire revenue for the state from tourism. And we calculate that, for example. We can calculate the increased investment of the state for a specific area that suffers from high-level trafficking, and therefore connect the act of trafficking with those specific traffickers in this specific zone with that increased investment that took to actually intercept them, take them, and so on. And of course, many other charges around both enforcement and the legal process itself. Sometimes we even use parts of old legislations from the finance side where many years ago those species could have been hunted. They no longer could be hunted, but the legislation stays so that we add that as well as what the state needs to be receiving if this was illegal. We take all of this together and we put them as one, all these elements together. And again, we receive damages awarded for every single case. For that matter, I would just say that what we do is that we start getting statements of this kind of generic calculations we usually have from the state organs that are entrusted of that, so that we actually get that prepared, and we use that for almost all of our cases. So it's not a work that needs to be done for every case again and again. We use the same calculations, and it only helps us that courts have been accepting the same calculations before. So that's basically it. If there's 3 points I want to get from this 8 minutes is, or the more important ones, is that one, a third-party independent observer of the entire enforcement judicial process can really make a difference in dealing with corruption within those elements. Secondly, is the use of private prosecutors that actually makes prosecution far more specialized and accountable as well. And third, the request of damages that when we start doing this for long, case after a while, it becomes just the rule and not the exception, and we don't have to argue for the actual principle of it. And in the French law, which most of our countries are French-based law, it is possible to do that within the criminal procedure and get the civil damages in the same process. Thank you.
Thank you very much, Ophir. It's encouraging to hear about your work, not only with the criminal prosecutions, but also with bringing forward damages and exercising these rights to extend those liabilities. I think it gives us a good example, and perhaps when integrated with the examples that Carol and Rika and Tawfiq were discussing, it seems to me that there's something there. But fundamentally, you highlight to us that we also have the rule of law context that we have to consider to make sure that these cases are actually going to be meaningful in practice. And speaking of practice, I'd like to invite our final speaker, someone who also has experience with thinking about how we can exercise these liabilities to protect biodiversity, to recover from harm. And this is Sébastien Mabille, who's a lawyer at the Paris Bar, a partner of Seattle Avocat, a French law firm that's specialized in corporate accountability law. He works on issues including deforestation due to cattle, soy, rubber crops. Notably, to our context today, he's also been central in representing the Calanque National Park in a civil lawsuit against illegal commercial fishers that were operating inside of the protected area. So I invite him to share his experience with us as we think about operationalizing these liabilities for biodiversity. Please, Sébastien.
Thank you, Jacob. Good afternoon, everybody. If you don't mind, I will speak in French. It will be more easier for me, and you can yes, and you can get the translation and
de sa réparation dans le cadre d'une affaire dans laquelle j'intervenais pour le parc national des Calanques suite à une affaire de pêche illégale dans le parc national des Calanques. Alors, le parc national des Calanques est l'un des 11 parcs nationaux français qui est situé au bord de la Méditerranée, à côté de la ville de Marseille. C'est un parc relativement récent, puisqu'il a été créé en 2012, et c'est un parc qui a cette caractéristique qu'il est périurbain, c'est-à-dire qu'il est à la fois terrestre et maritime, mais il est aussi situé aux portes de la deuxième plus grande ville française, Marseille, et donc soumis à des pressions qui sont importantes en termes d'activité illégale et notamment de pêche illégale sur un domaine maritime relativement vaste et vraiment situé à toute proximité de la ville de Marseille. Alors, l'affaire, c'est une affaire qui a débuté en 2015 à travers suite à une dénonciation anonyme d'un pêcheur qui dénonçait l'existence à la gendarmerie, à la police, de braconniers qui pêchaient dans les zones protégées du parc national des Calanques, c'est-à-dire dans les no-take areas, dans les zones de non-prélèvement, au sein desquelles toute forme de pêche est interdite. Alors, cette affaire a donné lieu à une enquête judiciaire et policière avec des moyens importants, puisque les 4 braconniers ont été placés sous écoute téléphonique pendant une période de 6 mois. Et il y a eu aussi des planques des policiers jusqu'à leur interpellation, le placement en garde à vue, et ensuite le renvoi de ces 4 personnes devant le tribunal correctionnel de Marseille. Et ça a donné lieu à un premier jugement le 11 juillet 2018, jugement sur le volet pénal, criminel, au terme duquel ces 4 braconniers ont été jugés coupables de pêche illégale dans le parc national des Calanques et également coupables d'avoir revendu le produit de cette pêche à des restaurants, à des écaillers, à des poissonniers de la ville de Marseille. Ils ont été condamnés à une peine de 18 mois d'emprisonnement sans partir en prison, puisqu'ils avaient une période probatoire de 3 ans avec une série d'interdictions, dont notamment l'interdiction de pratiquer la pêche sous-marine. L'affaire a été ensuite renvoyée devant le tribunal sur le plan civil, c'est-à-dire la réparation à la fois du préjudice subi par le parc national des Calanques, mais aussi le préjudice subi à la nature, c'est-à-dire le préjudice écologique. Alors, le préjudice écologique a été défini pour la première fois en France par le juge dans l'affaire de la marée noire de l'Erika. J'ai écouté avec attention Carol Jones qui expliquait comment la marée noire de l'Exxon Valdez avait profondément transformé le droit de l'environnement aux États-Unis et notamment les mécanismes de réparation. C'est aussi en France une marée noire, celle de l'Erika, qui s'est déroulée en 1999, qui a aussi permis de faire évoluer les règles de réparation du préjudice causé à l'environnement et qui a donné lieu par un arrêt de la Cour de cassation, la plus haute juridiction française, en 2012 et qui a défini le préjudice écologique comme toute atteinte à un intérêt non humain protégé par la loi. Et suite à cette décision de la Cour de cassation en 2012, le législateur français est intervenu en 2016 dans le cadre d'une loi sur la biodiversité pour introduire dans le Code civil français la définition du préjudice écologique et de déterminer également son mécanisme de réparation. Donc, vous avez ici un extrait de l'article 1246 du Code civil qui définit le préjudice écologique comme toute atteinte non négligeable aux éléments ou aux fonctions des écosystèmes et aux bénéfices tirés par l'homme de l'environnement. Donc, on voit à travers cette notion de fonction d'écosystème et de service écosystémique, on voit clairement que le législateur français s'est inspiré des principes dégagés dans le Millennium Assessment des Nations Unies, qui a permis de déterminer les fonctions et de définir les fonctions et les catégories de services fournis par les écosystèmes. Donc, sur la base de cette définition, le Parc national des Calanques a sollicité la réparation du préjudice écologique sur un montant très important, en tout cas un montant qui n'a jamais été demandé dans ces ordres de grandeur dans d'autres affaires, puisque nous sommes arrivés à une somme de 450 000 €, ce qui représente une somme très importante pour 4 individus. Il n'y avait pas de société qui était renvoyée ici devant le tribunal, c'était uniquement 4 individus, de 450 000 € que nous avons déterminé au terme d'une méthode d'évaluation du dommage environnemental. L'idée, c'était de déterminer, là ici, vous avez la carte du parc national des Calanques et vous avez les zones de non-prélèvement en bleu foncé, qui sont les zones dans lesquelles la pêche est interdite et des zones dans lesquelles sont menées différentes actions et sont engagés des frais de surveillance, de suivi scientifique, de balisage, etc., qui ont un coût pour le parc national. Et nous avons décidé, en tout cas proposé au tribunal, d'affecter la somme que nous obtiendrons à la réparation de l'environnement sur ces zones de non-prélèvement, de manière à restaurer un niveau de service écosystémique qui soit comparable à celui rendu par les écosystèmes avant les faits délictueux. Donc, je vais vous présenter succinctement cette méthode d'évaluation. Alors, nous avons d'abord estimé, évalué l'importance du dommage. Alors, pour évaluer l'importance du dommage, nous nous sommes basés sur les écoutes téléphoniques pour déterminer le montant total des prises faites par les braconniers, des prises illégales, et ensuite de les convertir au montant sur le marché noir de ces ventes pour finalement déterminer qu'ils avaient pêché près de 4,5 tonnes de poissons sur une période de 4 ans. Nous savions également que la biomasse dans les zones non-prélèvement avait augmenté de 2,7 kg par 100 mètres carrés pour les poissons. Et donc, nous avions la possibilité de convertir un poids de prise en kilos en surface impactée des zones de non-prélèvement en mètres carrés. Et nous avons également convaincu le tribunal que le fait de prélever un poisson qui est situé tout en haut de la chaîne trophique affectait tout l'écosystème qui était en dessous. Et donc, si les braconniers pêchaient 1 kg de mérou, le mérou avait lui-même consommé 10 kg de poissons de niveau inférieur pour fabriquer 1 kg de chair, ce qui nous a permis de multiplier par 10 le poids des poissons illégalement prélevés pour estimer que ce poids multiplié par 10 correspondait à l'atteinte sur l'écosystème. Et ensuite, nous l'avons converti en surface de zones de non-prélèvement impactées pour finalement déterminer qu'on était à 30%, ça correspondait à 30% des zones de non-prélèvement qui ont été impactées, et nous connaissions le budget qui était affecté à cette zone. Donc, nous pouvions convertir cette surface en euros, en somme monétaire, pour demander et arriver à ces 450 000 €. Donc, le tribunal s'il nous a permis de déterminer ce coût de 450 000 € en réparation du préjudice écologique. Le tribunal, par un jugement du 6 mars 2020, a approuvé notre méthode en la réduisant sur certains points uniquement pour aboutir à un montant de condamnation de 350 060 €, ce qui est quand même considérable dans ce genre d'affaires. Et le tribunal, donc là vous avez sa motivation, considérant effectivement que le préjudice écologique, le dommage à l'environnement, ne se limitait pas au prix des poissons illégalement prélevés, mais devait prendre en compte l'atteinte à l'ensemble de l'écosystème qui en résultait. Et que cette atteinte à l'écosystème était forcément plus importante que le seul prix des prises. Alors, les étapes prochaines, cette affaire a fait l'objet d'un appel. L'appel a été plaidé le 10 mai dernier devant la Cour d'appel d'Aix-en-Provence. Et je croise les doigts puisque l'arrêt de la Cour d'appel doit être rendu mardi prochain, le 29 juin de cette année. Voilà, je vous remercie pour votre attention.
Thank you very much, Sebastian. We'll be excited to hear what happens next with this appeals process. But again, really motivating to see that these types of cases are indeed possible. I'm conscious of time, but I'd like to finish by asking perhaps just two of our speakers a key question, which is that in light of the big picture, but also all of the granular details across all of these jurisdictions and the challenges and opportunities of bringing forward cases. I'd like to hear from, if you're available, Justice Antonio Benjamin, what is strategic? Where do we go forward from here? These laws are on the book, as Jay said. The economics and the concepts of harm and remedies are available, as Carol and Ophir and Sebastian have just described. What do you think we should be doing?
Well, first of all, congratulations to the panelists. I mean, this is absolutely fabulous. I learned so much in this tour de force around the world. I think if we split the liability, and I'm insisting on civil liability, because we're not discussing administrative or criminal liability, although we did touch upon those other classes of liability. If we split it into the pieces, something that Jay Pendergrass did in his presentation, I think there are good news and there are bad news. The good news is that, one, in terms of standing to sue, it's not that difficult to deal with that. It's a political decision, who we want to empower. Then if you move to the negligence component, again, it's not that difficult. You know, you either stick with the old-fashioned traditional in tort law negligence standard, or you move to strict liability. Then, in respect to who or against whom you can bring those suits, again, it's not that hard. It is a political decision. Is it joint and several liability, or is it individual liability? The difficulties reside in two areas, at least. The first is on causation. What are the techniques that we are going to use and be creative in terms of causation? And the second, and I subdivided it into two components, is about the damage itself, the different types of damage and the assessment of those damage, which is the area that Dr. Carol Jones, my dear friend, specialized on. So in terms of causation, what is new on the block? What is being developed in jurisprudence, especially in Latin America? And here we have new developments in Latin America. For example, the adoption not just of the reversal of the burden of proof of causation, but the in dubio pro natura principle. You prove it, the causation or the non-causation component. If we move to damage itself, and here there is a whole universe, and I was delighted to hear from my colleagues from Indonesia, because although they didn't frame this in the way we do in Latin America and in some continental Europe, we are now developing, and for example, my court has, this is completely pacified in the court, that in addition to all those damage that we have been discussing here, there is also moral damage, and moral damage of a collective nature. It's not just pain and suffering, something that in, c'est le dommage moral. And the question is, one, does dommage moral apply to environmental damage? And second, even more important, and that's where we have dozens of cases decided by my court So there is no discussion anymore whether this can be collective in cases of natural resource damage, deforestation. And the answer of the court is yes. We can have pain and suffering, which is a collective nature, an Indian tribe, a municipality, or the whole country. And my very last point, I was not expecting to speak, but since you asked me to speak at the very end, my last point is that we have to find ways to deal with statute of limitation. And here, a major development in Latin America in two ways. One, the recognition of a propter rem nature of environmental obligations. So the whole issue of causation, the whole issue of time passing disappears. Or, as the Constitutional Court of Brazil recognized, that the statute of limitations does not apply to diffuse collective environmental damage. So there is no environmental statute of limitation, because for us in many countries, and here, it's difficult to adopt the US model, and I think the Canadian too, that, here is not retroactivity. And then you find solutions that don't solve this problem in Latin American countries and in other parts of the world, because by constitutional provisions, law cannot be retroactive. So in this case, we have to come up with something new, and this something new is the recognition of the propter rem nature of environmental obligations. Thank you.
Thank you very much for that response. And you leave us a long list of homework, I think, of things to think about for the scholars, but indeed also for the practitioners. I want to thank everyone for your participation. This is a really unique and exciting group of people who are really kind of proving that I think this is an area of environmental law that, although legislation is on the books, really remains underexplored. And there's a lot of questions for practitioners, for scholars from across disciplines to explore. And I want to thank you for the time and the education, because anyone working in this space needs not only to come up with the barriers of law, but also of the socio-legal dynamics of what judges will tolerate, of the economics and the various approaches that we might think about, but of course also from the conservation science and the ecological questions. I think this is no doubt a challenge, but undoubtedly one that we have no choice but to confront, not only for conservation, but as David highlighted to us, but for future generations, and indeed a core issue also of human rights. So with that, I'd like to thank all of our speakers, all of our participants, the organizers, the World Commission on Environmental Law, the Environmental Law Institute, the International Network for Environmental Compliance and Enforcement, and my home institution, Lancaster University, for all of your contributions. And most importantly, I look forward to hearing about your future endeavors in court, because that's where it's going to take real body, where we stop talking about it and we start seeing it actually have implications for legal processes and for people and for conservation on the ground. So thank you again, and I look forward to fruitful collaborations in future. Please feel free to get in touch with us, and also to see our website where much of this work, many of our speakers have been participating, which is conservation-litigation.org. So thank you very much, and have a good morning, afternoon, or evening, wherever you may be. Take care.
Thanks, everybody. Thanks very much.